is DESORMIER, is that, am I pronouncing?
DESORMIER.
DESORMIER versus WINN, Commissioner of Education.
Thank you, Your
Would
Honor.
you like to reserve any time for rebuttal?
Yes, 3 minutes, please. Thank you, Your Honor. The issues here are first whether the EPC can suspend a teacher for 2 years based on the same evidence which the local school officials found did not warrant termination or other serious discipline, where the action against a certificate holder requires a higher quantum of proof than does a mere suspension or termination of employment, and there's insufficient reasons for the action given in the order. Second, whether the EPC otherwise violated the APA in this case by improperly rejecting the ALJ's findings of fact and relying on its own contrary and unsupported findings in so doing. And third, whether the EPC sufficiently justified its harsh penalty in view of the ALJ's recommendation that only a minimum penalty was warranted by the evidence.
I'd like to actually start with your second issue. It seems that the crux of the finding by the administrative law judge is that the personal gain or advantage language had a requirement that there be some sort of pecuniary gain. Now, isn't that an interpretation of law as to whether that provision requires pecuniary gain as opposed to some sort of reweighing of facts?
Yes, I think the question of the construction to be put on that language is a conclusion of law. The ALJ, he focused on pecuniary gain, but I think the cases that he cite also hold that there has to be some sort of tangible gain or advantage. The EPC in this case said that no, we don't think there has to be pecuniary gain. And ordinarily, if the case turned on a question of law, and if the ALJ were found to have been erroneous in his interpretation as opposed to that of the EPC, I think the proper remedy would be to remand the case to have the ALJ revisit the record under what this court would determine is the correct interpretation of personal gain or advantage. But I don't think that remedy is called for in this case for one simple reason. We've scoured the record in the case, and there's absolutely no evidence in this record that DESORMIER attained any kind of gain whatsoever out of this.
Well, if I check my email I want to look at my personal emails and I want to do it on my work computer, isn't there gain to me?
I don't know. Maybe, maybe not. But I think this is a case in which a violation must be proven by clear and convincing evidence. What was the evidence that DESORMIER attained personal gain or advantage?
Well, there's no real doubt, I don't think at this point, but that he did use a school system computer for his own personal purpose, that is to download.
Of course, and he violated the school board policy. And
there's no question about that.
He agreed. He stipulated.
So he was in fact using someone else's property for his own personal purposes as opposed to work purposes.
Well, I mean, that would require, I mean, you can assume that because someone does something voluntarily, they thought they were getting something out of it. But that would, in essence, wipe the whole personal gain or advantage language out of the rule, because it would mean anything that someone did deliberately or on purpose violates the rule, because we'll just assume that because they chose to do it, they were doing it for their own reasons. I don't think that, first of all, I think that's way too elastic a definition of that rule when the cases hold that this is a penal statute that we're operating under, and the people that it's subject to it are entitled to a strict construction in deciding what behaviors are subject to sanction.
Wasn't this gentleman, though, on the payroll and during planning periods when he was doing this? So he was receiving a paycheck. It wasn't his lunch hour. It wasn't after school hours.
Yes, and it was in violation of the policy, and there's no dispute about that. But
so running errands on your personal, on work time is not a misuse?
It may be a misuse,
And
but
it's not a gain of some kind? You're still
it's
getting
not-
paid?
I don't think you can assume that it's personal gain or advantage without some evidence. Nobody even asked, DESORMIER testified in the case. Nobody even asked him why he looked at these things. Nobody asked him, what did you get out of it? I mean, I think personal gain or advantage has to, at bare minimum, be construed to mean that you're in a better situation after you did it than you were before you did it, because those are inherent in gain or advantage. You have something after the act that you didn't have before the act. But what did he have?
His employer was paying him to do a job.
Right.
His employer was not paying him to download porn.
That's correct, but that doesn't.
There's a monetary feature to that. That'd be his paycheck.
Well, I mean, but that, of course, that was never alleged nor proven in the case. In fact, I have to take us back to the administrative complaint. The administrative complaint doesn't even allege that DESORMIER did this for personal gain or advantage. It only alleges that he violated the school board policy.
To file motions attacking the sufficiency of the complaint or the charging document?
No, because, I mean, it wouldn't have been well-founded because we didn't see the proof yet. Maybe they could, you know, I mean, the proof that was, and I will concede, there was no objection to the evidence that was offered at the hearing on this ostensible issue. So, I mean, I'm going to concede that. You don't have to go look for it. So, yes, it could be found that the absence of the allegation and the pleading was tried by consent. I think that's something you could do. But in any event, I don't think that you can construe these terms in such a way that they have no meaning anymore. I think if the legislature or if whoever promulgated this rule had meant any benefit whatsoever or titillation or gratification, it could have said so, because otherwise, then any violation of this
So if you go on eBay and buy something for yourself, then you violate the rule, but if you download pornography, you don't violate it. Is that your argument?
I'm not saying, no, I'm not saying, well, again, I think it's subject to proof. If you buy something on eBay, I mean, you have to have the evidence there as to what it was. The burden is on the commissioner to prove by clear and convincing evidence that the respondent derived personal gain or advantage by the use of the property. In this case, there was no evidence offered. I mean, we can speculate, but I don't think it's proper to speculate. I think it's a question of fact. It's something that could easily be proven by some kind of evidence, but there was no testimony from DESORMIER as to what, if anything, he got from looking at this thing.
So someone should have asked him, what did you get out of looking at these pictures? And if he
so.
said nothing, then that would
Well, then they could, maybe there's an admission, a prior admission that he made on the point or something. I'm just saying that it requires some kind of proof, because otherwise you've essentially eliminated that qualifying language from the rule. It means that anything anybody did that wasn't work is a violation of that rule. And it says, you know, you're using property for something.
And it says advantage, so if you use your work time to look at these things so that you're not doing it at home where maybe your wife or girlfriend might see them, that wouldn't be an advantage?
Well, I mean, it's going to be up to the court to decide it. You can construe it so broadly that it means anything. But I don't think that should be done because somebody chose that language for some reason. And, you know, in our opinion, the school board goes way too far. And I think it's...
But the basis of the ALJ's ruling was, again, going to this pecuniary gain. It wasn't really whether they established some other gain. The ALJ said it's got to be pecuniary in nature. Mm-hmm. And then the commission, who has a certain authority to interpret their own rules, says, no, that's not what this phrase is intended to encompass. Isn't that a pure legal issue?
No, I don't think so. It's a combined legal and factual issue because they have to show, when they disagree with the judge, they have to show what is the evidence in the record that they're relying on to fill in the correct conclusion. And they didn't do that. In the discussions, I think it's kind of interesting, in the panel discussions that are part of the record, they never once mentioned his looking at the cross-stitching or the Celtic dancing or the other things that he looked at. All they talked about was what they claimed were pornographic pictures contra the finding of the ALJ, who held that they were not. Now,
well, there were pictures, at the very least, there are pictures, he's looking at pictures of naked women in sexually explicit positions, however you define that.
Well, I think
he's doing it, and he's doing it in a school, right?
Well, I think it is significant because if they're resting a conclusion on the facts that the pictures were pornographic, that to me is clearly a finding of fact. And it's one that the ALJ found against that. He found that they were not pornographic, whereas several of the panel members said, well, these are pornographic images, he's looking at porno. But there was no question they were sexually explicit in a classroom situation. There is no question about that. But, I don't think... So is pornography alone the only thing that's prohibited in a school situation? I didn't say that, and I'm not suggesting it is. I'm suggesting we have to look at what the findings were by the EPC in the case and how they justified reaching their conclusion. And it seems to me if they reached their conclusion based upon the proposition that these pictures were pornographic, when the evidence in the record as found by the ALJ was that they were not, without finding that those findings are not supported by competent substantial evidence, I think they violated the APA.
Where did the commission say they were pornographic?
We've cited in our brief several passages in their deliberations where several of the panel members said that the pictures were pornographic. He was looking at porno. He was looking at porno and then later would have been in proximity to students, none of which was supported by any evidence in this record.
But those weren't the findings ultimately of the commission.
No, they didn't incorporate that language in their final order. But I don't think you can disregard it. I mean, that certainly was their motivation. And if they had an erroneous belief of how far they could go in rejecting the findings of the ALJ, then I think that you have to look at that.
Well, now wait. You've heard us talking up here during the course of a lot of conversations. But what actually goes into the final the final document that we produce really may have little or nothing to do with the conversations that we've had up here with counsel. It may simply be exploring other notions. So I don't know that you can leap to the conclusion that just because there was discussion in a panel setting, in a collegial setting, that you have to incorporate that into the final order.
Well, I think there's a clear distinction between review of an administrative agency's actions and the actions of a court. I mean, a court's determinations are given a far broader latitude and a broader presumption of correctness.
Isn't the standard of review, though, clearly erroneous?
No, the standard of review in this case is whether the ALJ's findings were supported by competent substantial evidence. If they were, then the agency cannot reject them. That's verbatim language out of the statute 12057, which we quote in whole in our brief. On the first issue, my time is going to be short, but the statutes and the constitutional authorities that we've cited in the brief, we think, show that the legislature never intended that the EPC could, through its own personal, any panel of the EPC, through its own personal standards of morality, simply reject without explanation actions of local school officials who review the exact same evidence and decide that whatever a teacher did is not worthy of suspension or termination or any severe discipline, and decide that they can deprive the teacher of his livelihood and the school board of the teacher's services just because their own personal...
The commission has authority over licensure.
Yes, they do, but subject to certain limitations, and the limitations that are the ones that we have, I think, have set forth in the brief. I mean, every statute gives the authority over whether somebody can teach or not at the local level, gives that authority to the local school officials, not to the EPC. The Constitution is also involved in that it gives authority to the local school boards and superintendents.
But aren't they two different entities, each making a decision based on what their mandate is?
Well, they are, but I don't think that means that the agency, the EPC panel, can simply disregard what the local official's determination was, and they did in this case. There's nothing in the final order that even makes mention of the fact that the school board didn't think this was worthy of serious punishment, but we think that it is. Which I think is basically just a rejection of the ALJ's ultimate finding in the case, that this guy didn't do anything under the statutes and rules cited that warranted anything more than, at the most, a minor reprimand, which is the least penalty that could be imposed. Now, you have the ALJ's conclusion, which is entitled to substantial deference under 120, and you also have the school board's conclusion, which reviewed the same evidence, is presumably familiar with the moral standards in the county more so than these panel members who come from all over the state, and there's no evidence that they have any close understanding of what's going on in that county. And what I'm suggesting is that under those circumstances, unless the EPC can point to something that would justify its just kind of summary rejection of the views of the local officials, I think their final order is deficient. I think it's not what the legislature intended it to do, and it's something that this court can correct.
You had one point concerning the sanction to be imposed, and there's the case law that is properly cited that talks about under what circumstances the commission can increase sanction. But in this case, since the ALJ found no violation, there is no sanction.
Well, but he did address the sanction, and he cited to evidence in the record that supported his...
How do you find someone not guilty and then say, well, you know, but here's what if the person is guilty, here's what the punishment that I would have imposed?
I'm not aware of any...
Trial judge and someone's found not guilty, and as you enter that judgment of acquittal, you then say to the defendant, and had you been convicted, I would have given you life.
Well, first of all, I'm not aware of anything in 120 that prohibits an ALJ from making an alternative recommendation regarding penalty, even though he has found that the evidence does not justify a finding of any violation. I'm not aware of any case law that says that as well. I mean, I don't think that... I've never even heard the term dicta applied.
Assuming that the statute can be interpreted in that fashion, I mean, how can that be anything more than simply an offhanded recommendation?
Because he cites to the record, and the school board's burden is to cite the evidence in the record to justify a different conclusion than the ALJ made. Now, I suppose, I don't know what the correct outcome would be then. Suppose we were right on argument that they disregarded his reasoning, and then what are we going to do? Remand it back to the ALJ? Now that there is a violation, now let him say the same thing that he said the first time, which is, I've looked at the evidence on aggravating and mitigating factors that's present in this case, and at the most it justifies a reprimand, which is the lightest penalty that can be imposed. I mean, I think that would be kind of a pointless exercise.
All right, we're just over your 3 minutes rebuttal. Would you like to reserve the remainder of your time?
Yes, Your Honor.
May it please the Court, my name is Edward Bow, and I represent...
One second.
Sorry, Judge.
All right, go ahead.
Please the Court, my name is Edward Bow, and I represent the Florida Department of Education. If I could begin where we left off with the third issue regarding the penalty. The Court made a good point, which I think we raised in our brief, which is it is very unusual for an administrative law judge, having found that the person, in his opinion, did absolutely nothing wrong, to then make a penalty recommendation. I can't say that I've ever seen that before, but even assuming it was appropriate for him to do that, the problem is, and it's clear from his order, he was under the erroneous belief that in order to impose a suspension, aggravating circumstances had to be proven by the department. He flat out says that, and that's the way his order reads. That's just wrong. Under the relevant rule, 6B-1.0072E, the guidelines, the top of the guideline range was a 2-year suspension. So the Commission did not need to find, and we did not have to prove any aggravating circumstances for that penalty to be imposed. Further, this was not a summary hearing as they would like to suggest today. I believe the transcript of the EPC hearing in his case was over 50 pages, and there was a great deal of discussion about what the penalty should be, and the panel members were understandably concerned. The panel consists, of course, of teachers, educators, and lay people, but the teachers on the panel couldn't believe that he had the time to do this during his planning periods. They expressed their belief that, we don't have enough planning time. We don't have enough time to do the things we need to do to be prepared. We have to spend time at home even to be ready, and they were very upset about it. So and furthermore, essentially getting paid to play hooky at school looking at sexually explicit images. They were understandably upset about that. And
what if it were Minesweeper? What if it were looking at his personal Yahoo or AOL account?
Well, a policy decision had to be made in this case, and the agency here drew the line at least at sexually explicit materials. Whether Minesweeper, playing blackjack, whatever, it might be harder for us to prove a gain in that situation. The gain of entertainment, I don't.
Because that's actually exactly where I'm going with this. You take the position in your brief that the language is unambiguous. That gain or advantage. What's clear and unambiguous about that phrase?
Well, it's clear.
Can't playing computer games be a gain and advantage? Because, as has been pointed out, you're getting paid. The school board is cutting you a check for the time. Looking at your personal email account, isn't that some sort of advantage?
It would be being paid to work and you're not working. So that could be viewed as a financial gain. When I said in the brief that the rule was clear and unambiguous, what I was saying was it's clear that the rule is not limited solely to financial gain. I think...
Where does it say that?
Well, it says personal gain or advantage. If the agency had intended for it to be limited to financial gain, it would have just said financial gain or monetary gain. It wouldn't say personal gain or advantage. I think the word advantage clearly indicates that it would not... If it were just talking about money, they wouldn't say gain or advantage. They would just say... As
counsel points out, there has to be some meaning to gain or advantage, or you wouldn't need to say it. If simply the use of school board property was sufficient, then you don't need the phrase gain or advantage. It has to mean something. So the question is, what does it mean?
Well, I think in this case, there was a substantial amount of time that Mr. DESORMIER spent on his computer. It was not a de minimis violation. I don't think the state would waste the time if someone played Minesweeper for 2 minutes to seek disciplinary action. We're talking about a period of time from the beginning of the 2003 school year until February of 2004, anywhere from 1 to 5 days a week, anywhere from 5 to 30 minutes on the days that he did it, and that was from Mr. DESORMIER's own testimony. So is gain or advantage defined by the amount of time? I think it could be, because I think it's easier to prove a gain. I think if you did it 1 minute versus hundreds of minutes... What about 10 minutes? I don't know. I mean, it's a question for a different case, Judge. What we have in this case are hundreds and hundreds and hundreds of sexually explicit images which were introduced into evidence. Mr. DESORMIER did not deny that he looked at them. And I think the act speaks for itself. Some actions might require a degree of interpretation. Someone checking the Red Sox scores, that would maybe be harder to prove a gain. But Why would anyone do that? Well, the season's over, but he actually testified at the hearing, Judge. That's why I'm using that example. He testified that he also used the computer to do those sorts of things. But I guess my point is some acts speak for themselves. If a teacher has sex with a student, would we really have to ask the teacher, why did you have sex with a student? I mean, it speaks for itself. A grown man accessing hundreds of sexually explicit images requires no interpretation. It speaks for itself. You would do that for no other reason than for some form of sexual gratification, and this rule has been interpreted for years by numerous administrative law judges as well as the EPC as covering sexual gratification as a gain. They've defined that as a gain. We cited at least 3 cases in our brief where 3 different administrative law judges, Judge Manry's colleagues, had all the way back to 2001 held that viewing sexually explicit images constitutes a violation of this rule. Facts identical to this case.
Why don't they just change the rule?
We don't need to change the rule because it was clear to everyone until the administrative law judge in this case. Depending what happens here, maybe we will, but it's been clear to everyone. To the best of my knowledge in the research that I conducted, this was the first administrative law judge ever to hold that the rule required proof of financial gain. These cases were brought to his attention in our proposed recommended order. He was aware of them. And for whatever reason, in his recommended order, he just chose not to acknowledge them. He chose to not acknowledge that the EPC, this is the EPC's rule, that it has consistently interpreted the rule as not requiring proof of financial gain, just completely disregarded it. And if I could jump back to the point about the penalty, it was within the guidelines, and the EPC explained its reasoning. And they're latching on to this concept of, well, it's pornography. Was it pornography or not? It's clear, reading the hearing, that they were just using the word pornography as shorthand for sexually explicit images. I mean, they could have just said that every time, but furthermore, they've suggested that Judge Manry found that it wasn't pornography. I don't see that in the record. What he said is that because these photographs were accessed through Yahoo and they were posted on Yahoo personal websites, Yahoo is not a pornographic website. Well, that's true. Yahoo is a search engine website. It's a publicly traded company. Yes, it is not a pornographic website, but he never said that the images were not pornographic, but I don't think that matters anyway. The images are what they are. They were undisputed. They were introduced in the record, and the court's free to review them. They were unquestionably sexually explicit images and probably pornography, but whether they're pornography or not, they were clearly sexually related, and it was just simply improper for Mr. DESORMIER to spend countless hours where he's being paid to teach and plan to access these materials. If I could jump to the second issue, which we've touched on, the deference rule should apply in this case. Even if it could be properly argued that the EPC disturbed a true finding of fact, the deference rule should apply, which this court has recognized, I think most recently in Gross versus Department of Health in 2004. And although the rule was not applied in that case because it involved the interpretation of a statute as opposed to the agency's own rule, the opinion contains an excellent discussion of what the rule involves, and the rule essentially provides that overriding policy considerations sort of take precedence over findings of fact by an administrative law judge. And overriding policy considerations include instances where an agency is interpreting its own rule. And that's what we have here. The agency interpreted its rule. It's interpreted the rule for years as encompassing sexual gain or sexual gratification as a gain, and that's an entirely reasonable construction of its own rule. This is nothing new, what happened in this case. So to the extent that a factual finding was disturbed, we would argue that this is a classic situation where the that deference should apply to the agency's decision. If I could jump to the five, just briefly address the 5 cases that were cited in the initial brief on this issue, which the appellant claims support reversal. The first is the Gross versus Department of Health decision. Completely distinguishable, first of all, because there were truly facts in dispute in that case. The act didn't speak for itself. I believe they were doing some sort of scan of a patient. There was a chamber that should have been loaded with dye. It wasn't. It was loaded with air. The air was injected into the patient. The patient died in that case. The question was, should the doctor have personally looked at the chamber and checked it? Well, that doesn't speak for itself. Did that violate the standard of care or not? There were competing experts. One expert said yes. One expert said no. The ALJ believed the physician's expert. So there was conflicting testimony in that case, first of all. Secondly, the case involved the interpretation of a statute, not a rule. And this court went out of its way twice in that opinion because it was discussing the deference rule and said, we're not going to apply the deference rule here because this is not a rule that was enacted by the Department of Health. This is a statutory provision.
What about Bush versus Brogan?
Was that the second district case in 1999, Your Honor?
It is.
That case was not the best written opinion in the world. It wasn't even clear exactly. The person in that case was charged with gross immorality or moral turpitude, and apparently it was a teacher that had married a former student once she turned 16, and then they got into a fight, and he apparently punched her. It wasn't clear if the morality charge was based on marrying a former student. They never actually clarified that in the opinion, or for punching her. We know that the facts about the battery were in dispute. The opinion is clear about that. So assuming the charge was based on the punching, there was a contested factual issue as to how the woman ended up with a split lip. Furthermore, that involved, I believe, a statute, not a rule. Gross immorality or moral turpitude was a statutory violation, not a rule violation. So again, contested facts and a statute as opposed to rule. So the deference rule would not have applied in that case. And essentially, it appears that what the agency did there was just reweigh conflicting testimony, which is not what we have here. We know what Mr. DESORMIER did. We know when he did it, where, and how, and I think the why speaks for itself, like I've noted. The Costin decision, they also cite, which this court decided in January of this year, Costin versus Florida A&M University. Now, that did involve a rule. However, there were contested facts in this case. The employee was fired.
That's the computer.
The computer person with a law school. And what they had to show was, to justify the termination, was that there was misconduct and further that there was an adverse effect on the employer. Both of those issues were contested. The employee said, I didn't do anything wrong. I had permission to do whatever I did from the dean of the law school, and it turned out I think he had to get permission from the main school headquarters, if I'm remembering that correctly. So the ALJ had to make factual calls, and in that case, the ALJ found, well, yes, there was misconduct, but no, there was no adverse effect on the employer. That is a true factual finding. And A&M stepped in and said, well, yes, there was an adverse effect. You just can't do that. I mean, that was a pure factual finding that they tampered with. And even though that case did involve a rule, this court noted that the agency failed to comply with, 120.571L, which requires an agency, when it's rejecting a conclusion of law, because what the agency tried to do in Costin was say, well, we're just interpreting our own rule. Well, they didn't follow 120.571L, which requires the agency, if they're going to reject a legal conclusion, to state the reasons for doing so with particularity and explain why its interpretation or legal construction is more reasonable or as reasonable as that of the ALJ, and they just simply didn't do it. Their order was completely silent, didn't comply with 120.57. Further, in Costin, this court noted that the agency's interpretation of its own rule made absolutely, completely no sense, because what the agency was saying is, well, anytime there's misconduct, there's an adverse effect. And the court said, well, if that's true, if there's automatically an adverse effect, then that would just completely eviscerate the language and make it meaningless, and, we're not going to buy that. Much different from this case, where we would submit that the agency's interpretation has long been understood by everyone until now to include both monetary and some forms of non-monetary gain. The Stinson case is also cited, which I'm somewhat familiar with because we ended up handling the fees issue when it was remanded back down. That case was a classic contested facts situation. The teacher was charged with helping kids cheat on the FCAT, essentially. The department had numerous witnesses, supporting its position. The teacher had one child, and the ALJ, which was the same ALJ as in this case, by the way, decided to believe the one child over the many, and that was his call. And the EPC stepped in, and they shouldn't have done it. They decided they were going to reweigh the conflicting testimony and believe the many over the one. And the First District said, well, no. Just one witness is competent substantial evidence. That was his call. He could choose to believe the teacher and the one child. So, again, totally different from our case where we know exactly what happened and where and when. There was no dispute. Mr. DeSormier fully admitted it at the hearing and did not object to the introduction of the hundreds of images that we produced. I believe that's all their cases. So all their cases involve either true factual disputes or the interpretation of a statute as opposed to a rule, or a situation where even if a rule was involved, the agency did not comply with 120.571L, which we did in this case. The final order clearly delineated why it was rejecting the ALJ's conclusion of law and why its interpretation was as or more reasonable than his. So we would submit that all of the cases that are recited by the appellant on this issue are distinguishable. We believe, and we cited the DeLawyer decision, although it's a very short decision from the 3rd District, I think from 84, is controlling here. And what it basically says is that where you have uncontested facts, and the uncontested facts clearly establish a violation of the law, the agency is free to step in and make that correction, and that's all the agency did here. All the agency did here was treat Mr. DeSormier like all the other teachers that had come before him, at least 3 that I could find that were cited in the brief, and basically hold that if you access for substantial periods of time hundreds of sexually explicit images while you're being paid to teach and you're doing it during your planning time at school, that's a misuse of institutional privileges and that there is a gain there. That's all they did, was take the undisputed facts and apply it to the law as it had been applied by that agency at least as far back as 2001 with respect to images on computers, and even longer. The rule has been applied for 20 years or more to situations involving dating students and relationships and things of that.
And gain you define as this prurient...
I think sexual gratification would be defined as a gain by a lot of people. Unfortunately, the Westlaw is full of cases where teachers were disciplined for initiating romantic relationships with students. Unfortunately, it's something that occurs quite often, and it was a gain for the teacher. They ended up losing in the end because, of course, it was immoral, unlawful, and they were caught, but they clearly saw it as a gain. And Mr. DeSormier, he was getting something out of it, or he wouldn't have accessed hundreds of images over a substantial period of time when he was being paid to plan. And he was otherwise a pretty good teacher from what we can gather from the record. So why would a great teacher decide he's going to spend his planning period looking at pornographic images or sexually explicit materials? He was getting something out of it, and it speaks for itself. I don't think we had to ask him the question why. And as Judge Kest pointed out, if we had, he probably would have said in any event, well, nothing. What are we going to do then? We can't charge him. I mean, all the person has to do, they can do whatever they want on the computer, and all they have to then do is deny that they got anything out of it. I mean, it's absurd. Certainly in this context where we're dealing with the material that we have.
What burden was it?
It was our burden, but again, the act speaks for itself. Some acts, I would submit, require a degree of interpretation, like in gross. We know what the doctor did, but was it improper or not? That you had to go another step. Looking at hundreds of sexually explicit photographs, that requires, in our view, no interpretation. It can be done for no other reason that we can think of than for some form of sexual gratification. And we would ask that the court affirm on the second issue. Now, if I could jump back to the first issue. First of all, the first issue, which is basically arguing that the EPC can't take action because the district really didn't do anything to him. Well, they didn't fire him. They did reassign him for a substantial period of time to an area of the district which did not require a teaching license, so they did take action against him. But in any event, not preserved. This was not argued anywhere below at any time, either at DOA or even at the final EPC hearing. They knew we were seeking a suspension because we filed exceptions requesting that the EPC impose a 2-year penalty. So they were on notice we were asking for a suspension. They could have filed a motion or made any kind of argument at the EPC, and they failed to do it. This was never raised at any time below. Furthermore, their argument is completely refuted, and this is cited in our brief, by Section 1012.796 of the Florida statutes, which provides, subsection 1A of that statute, that the state can investigate and prosecute to completion complaints that are brought to it regardless of the views of the reporting agency. I mean, it's right there. We don't, it doesn't matter what they did. The state can take action irrespective of the views of the reporting agency, which in this case was the local school district. And that makes sense because it ensures that there is a uniform system of discipline throughout the state, which is what the EPC is there to do. And I would also, I've got 10 seconds left, note that I think what essentially they've done is raise sort of a res judicata and collateral estoppel argument. They're just not calling it that. And, of course, there are a number of cases we've cited which hold that they're separate governmental units. Thank you.
Thank you, Counsel.
First of all, I think we raised the issue the first time that we could have raised it, which was after the EPC took action based on the complete factual record. We're arguing that looking at this record...
Why couldn't it have been raised prior to the proceedings in front of the Commission?
They suggested that we could have done it in a motion to dismiss, but we didn't know what the evidence was then. We didn't know what evidence
they... You knew that they were in front of the Commission seeking a suspension of the license.
No, we knew that they had the boilerplate allegation in the complaint that we are seeking sanctions which could range from reprimand to termination.
Your position is that the Commission had no authority to impose those sanctions.
Without at least addressing the issue in some way. I'm not suggesting it's a blanket.
No, that's not the issue. That's a separate issue. Okay. In your brief, you're taking the positions that the statutes do not give them the authority to effectively second-guess the local school district, that there's local control of the school system, and they don't have the authority, absent the local board taking action, to take independent action.
I don't think that our argument runs that far, because I think we qualify it as saying without more. I can envision countless cases in which the local officials are incompetent or they fail to consider some relevant evidence or something like that. If that's the case, clearly the EPC can act, but not. I don't think they can brush aside the views of the local people without a mention. If the court finds personal gain or advantage is ambiguous, it has to construe that strictly in DESORMIER's favor and against the Commission. If we now find that the real issue in the case is did he derive sexual gratification from the images on the computer, I submit to you that is a pure question of fact, one that's readily susceptible to evidence. Can we infer it? No. It might be likely, but that isn't clear and convincing evidence that he gained sexual gratification from those images. He might have been a student.
Instead of using the phrase gratification, you were to use the phrase stimulation.
I'm going to take the Commissioner's attorney at his word. He says that the issue in the case was sexual gratification. If he says that's the finding on which this man's license was suspended for 2 years, you have to find proof in the record that the Commissioner carried his burden of proving that DESORMIER was sexually gratified by these pictures by clear and convincing evidence. And there's no such evidence in this record. On the issue of whether they were pornographic, the ALJ found as a fact that the school board filters out pornographic images from the school computers. They did not filter these images out. Therefore, he found as a fact that the images are not pornographic, and I believe that finding is supported by...
Pornography is based upon what a filter picks up?
That is the school board. He concluded from the actions of the school board to not.
That can't be logical. You can't. How do you define pornography based upon the ability of a filter to pick it up?
I think it's a relevant fact, and I think it's competent evidence. And there's no evidence to the contrary. There was no evidence offered by the commissioner that these images are pornographic. And finally, on the deference issue, I don't know what the EPC's special expertise is in matters of morality and sexual gratification. I don't believe there is any, and therefore I don't think it's entitled to deference.
All right, thank you.
Thank you.